Okay, so welcome everyone, and thank you very much for attending just this basic wills training. So what I want to do is go through some important points around wills and estates. What is a will, why it's important to do one, why it's important for your clients to do one, how you can do one legally. It doesn't matter whether you're an administrator, you're an accountant or a financial planner. Where the lines are drawn between providing legal advice, which obviously we don't want to get into, because if we provide legal advice, then the Legal Professions Act can effectively take, or the law societies can take action against us. Although to date, there's only really been one or two cases in the last 50 or 60 years. So it's not a big issue, particularly with the introduction of do-it-yourself wills, etc. So I want to show you how to do it legally, and more importantly, how to do it on LightYear Docs, which has an implemented patent pending process that enables you to do the will without really going in and making up or mucking up the guts of the will, so that effectively it would be construed as providing legal advice. So let's go through and have a look at some of these important issues. So if you die without a will, effectively what we do is we're known legally to have died intestate. And then all of your worldly assets are to be divided up according to each state's intestacy laws. So I'm up here in Queensland, so we have the Succession Act of Queensland, which I think is 2006. And so then if we've got a spouse or a de facto spouse, no children, then everything goes to her. But it starts to get a little bit muddy. If you can imagine, you've got stepchildren, you've got de factos, so on and so forth. And the problem about that, even if it's a basic estate, there's not that many assets there, then what happens is if you die intestate, generally the public trustee steps in and starts to do the administration or the management of that intestate estate, which will generally cost many thousands of dollars, $10,000, $20,000, $30,000. So really for your clients, and you're probably getting feedback from them that they want to get their wills done. I think COVID has been a really good flashpoint for us around that. And ideally, if you're going to do that, it's also worthwhile doing an enduring power of attorney. An enduring power of attorney is simply that someone acts as your attorney in the event that you can't manage your affairs. So, for example, I just sold mum and dad's home. They are both in a nursing home, and they could have signed all the contracts, but it was just too difficult for them to do that. It's just too overwhelming at their age. And they're in their mid to late 80s. So myself and my brothers had their enduring power of attorney, so we were able to sign on their behalf. Now, that power of attorney had to be registered with the Land Titles Office in South Australia, but effectively that's what you can do. And so your power of attorney can do a whole range of things, look after your financial or your health, who's going to look after your health, so on and so forth. But today we're just going to have a look at a basic will for our perspective. So let's have a look at a few key terms. And as I said, if you've got any questions along the way, please let me know. So the first off is a will is a legally valid document that details how a deceased estate is to be distributed amongst their family and charities. So when you do a will, effectively you'll find that there needs to be two signatories, and I'll go through the whole process for that a little bit later because it's embedded into our documentation. So I don't want to steal the thunder there for you. So I will cover that. And I will cover the signing of each and every page by the testator and the executors and who has to sign and what. So we'll have a look at that a little bit later on. The executor is the person who's appointed under the will to manage the estate, or what we call minister the estate. So, for example, you'll find when we get down a little bit later on that there may be specific gifts paid out to some. There may be, for example, also funeral expenses, taxes to be paid, any loans that the deceased owed to someone has to be paid. So as a consequence of that, they go through that management position. Now, it's important when you do deal with your clients around this is the executor needs to be someone who is financially and financially smart, particularly if there might be second marriages or disaffected children, because under each state there's what we call an opportunity to make a family provisions claim if you are an eligible person and you feel though you've been left out of the estate, or more importantly, you didn't get what you believe you deserve from the estate. And there's been a number of them, and it can take like years to resolve, and hundreds and hundreds of thousands of dollars to resolve those particular issues. So the issue about that is that if there's potential when you come down, if your client's been married before, they've got a problematic child, they don't get on with this, or they don't like the daughter or the son-in-law, then you've just got to be really careful that in your choice of executor, you have to have someone who's quite strong-minded and will withstand a barrage of nasty letters from lawyers, particularly if they're family provision lawyers. So you've just got to be really careful about that. So the typical place of, goes from dad to mum and mum's executor, depending on the age, probably doesn't make that much sense. I mean, they can surround themselves and get great advice from you guys, and it's important for you guys to make sure that you're part of that administration process. But at the end of the day, it's a tough call, because if they're getting lawyers, and honestly, I've seen some pretty ugly things, it can be extremely stressful. To that end, don't ever become an executor of your client's estate. I've seen too many problems around that, because generally it doesn't matter what you do, someone is going to have a go at you. And I've seen criminal complaints against executors, and these are accountants who are acting as executors. So the best thing to do is get an executor and then make sure you're in the position of being the advisor to the executor, if that makes sense. Be the advisor. Don't be the executor, be the advisor. And also there's an issue there as well, that if you are the executor and you're an accountant, it's very hard for you to charge advice fees. And even if you are able to do so, you're going to find the beneficiaries will probably, they'll probably make a complaint against it. So there's no upside. Now, the administrator, if there's no executor, then, for example, we might put in mum as the executor. And then when we come round, the will is old, but mum's dead. So if there's no executor, then we need to go and get an administrator. And generally, it may be one of the family, but it may be the public trustee. So it's, again, as soon as we need to do these things, it becomes very expensive, because the only way to handle a lot of these is to go to the Supreme Court in any state that you're in, which is it's not the district court, it's not the magistrate's court. You've got to go, to the highest court in your state, which is the Supreme Court. And of course, that's a very, very expensive process. A beneficiary is simply a person who's designated to receive a gift. The old form wills call it a bequest from the deceased. It may be specific, or it might just be the residual of the estate, which we'll get into. Probate, once we get the will, we actually have to prove that the will is the last will and testament of the deceased. And now we can go down the track and do that, but then again, it could be subject to challenge. So generally the executor and their advisors, which would be you guys, would go to the probate division of the Supreme Court and get it stamped as being the last will and testament. So once that happens, then you can go down the track and the executor can do all the executory things that they need to do, the administration, and give the bequests. Without that probate, again, it can be challenged. So the main thing there is with probate, between death and getting that probate could take anywhere from 2 to potentially 6 months. Now, the initial administration, once we've got probate, then the next step is that the executor will go and pay off all debts, file tax returns for the deceased, pay any taxes, funeral expenses, any other things that the deceased owed at the time, or just paying advisors such as yourselves, will all come out of that initial administration. So again, it's important to make sure that you guys know that process as well. The next one we know is specific gifts. So specific gifts, and you'll see when we get to the our LightYear Docs will, it's an important part of the estate is that you're able to give like Johnny, $50,000 shares, or for example, your Jaguar convertible. Who's that to go to? It can either go into the residual estate or the big lump that is the estate. But I prefer actually giving specific gifts because specific gifts have a lot more power than general gifts. So, for example, I might give $20,000. I dealt with a client the other day. He wanted to give $20,000 to each of his children and then $20,000 to each of his grandchildren, who are not only alive at this time, but also alive at the time of his death, because obviously it'll go down the track. So we built that process in there. So that's a specific gift. Likewise, you might have artwork that is specifically gifted. There might be jewelry and personal effects. Again, you can give a specific gift, but you enable the executor to distribute it fair and reasonably amongst everyone else, which is usually the case with personal effects and also jewelry. So what we do is we look at those specific gifts, and anything left over after the initial administration, the fees that are being paid to you as the advisor to the estate, anything left over, it goes to the residual estate. And generally, the first person is the main, or what we call the principal beneficiary. So they'll take whatever's left over of that residual estate. And usually that may well be the spouse, or you can divvy it up. So it could be like the spouse, your brother, your sister, or to get 33%, or your spouse to get 50%, and then your brother and sister to get 25% each, or your two children from your first marriage to get 25% each. So we can divvy that up, whatever's left over. But if they're not alive, the main beneficiary is not alive, then it goes down to the secondary beneficiary, and then they take. And if there's no secondary beneficiary, it may go down to the tertiary. But at each one of these points is that we can insert into the document to say, okay, well, if the main beneficiary is not alive, is it to go to a second beneficiary, or is it, for example, to go to the main beneficiary's children? So we've got that sort of option there as well. And the same, the secondary beneficiary, they might say, well, if they've got kids, it goes to them, their children, rather than passing down. So we've got a bit of flexibility around that. Renunciation is not a big one in Australia. It's very big over in the US, mainly for tax and social security. But we have been called upon here in Australia to do a couple of renunciations so that we've got a position that people want to keep their social security benefits, so therefore they don't want those assets to come in and be part of their estate. A testamentary trust is not really for basics, and we'll go through that, but a testamentary trust effectively is a trust like it's essentially a discretionary trust, discretionary / fixed. And when I mean fixed, it might have terms and conditions in there that, a child may be a beneficiary, but they're not able to take capital until age 25. Or the executor is to be the trustee of the testamentary trust, and then the child can take over once they're 25. So what we do is we parcel it up into a trust for the benefit of one or more beneficiaries. It does have an impact that the benefit from a tax perspective is that any benefits that are paid out to minors, normally there's penalty tax rates for minors, doesn't apply through a testamentary trust. So again, we won't look at testamentary trust. We'll look at this a little bit later on. One of the things I'm building over the next month or so is a dedicated course for wills and estate planning and succession planning. So this will be one of the basic parameters of that. So if you've already done this, then keep that on record. You've done it, because that'll give you a credit for that course. Now let's have a look at a basic case study. So we've got John Smith has a house which is jointly owned with his wife Sally Smith. So I've put in a few little spoilers in here. So what happens here is that where we have a house that's jointly owned, so there's two ways of owning property. It's either jointly or tenants in common. So tenants in common means, for example, you and I might own a house, but we go into a partnership, and that partnership at law is called a tenant in common. Whereas if we go in jointly, and typically it's a given in Australia that if you buy a house with your spouse, then it is jointly owned. And what that means is that when one person dies, the surviving partner automatically gets their entitlement. So if there's a property and it's jointly owned with the wife for John Smith here and Sally Smith, that's not going to form part of the will, because as soon as John dies, Sally Smith now becomes the whole owner of that property. Now, of course, when Sally dies, that will become part of Sally's estate. And as you can see, that starts to create an issue if we've got, for example, Sally was John's second wife, and he's got kids from the first marriage. So again, once you start doing that, it's not a basic will anymore. We just need to up our ante a bit. But let's get down to the basics. So here, it's his first wife. So effectively, we don't cover that inside the will, unless, of course, we put in there that Sally has predeceased John. So John might make a will. In fact, I had a look at a will the other day that was made 30 years ago. And the client had been married twice since that time. So the will was effectively invalid. So he would have died intestate. But anyway, so we may have to cover that issue of that property if Sally's not alive, if she predeceases. If we don't do it through a specific gift, then it'll be part of the remainder of the estate, if that makes sense. John's got $200,000 investments. $650,000 in an SMSF super fund pension, which has a reversion to Sally. So another thing there is your will, or when you do a will, can provide an indication of what to do with super, but your will can't, for example, particularly if there's an SMSF, can't direct the trustee of the SMSF to pay the deceased benefits into their superannuation benefits into the estate. In fact, given the issues around family provisions claims, remember that's where a child or any eligible person, which can include grandchildren, for example, make a claim on the estate, then it doesn't make sense to put superannuation over there. So we've got a separate document sitting on the LightYear Docs side called an SMSF will, which is like a will, but it's only for superannuation benefits for the SMSF. So it ensures that the superannuation benefits generally don't go out to the estate unless all the beneficiaries who are able to receive from the superannuation are all dead. And, we've got a mass cataclysmic blow up or explosion that destroys the whole family. But anyway, we still have to cover that one. So he's got a reversion to Sally. So we should all know what a pension is. So we just start up an account-based pension in a fund. And generally we can build in automatically estate planning. So it goes from here, John, and then it goes to Sally. So like the house, it's jointly owned. So that again, when John dies, that income stream or that account-based pension, the account itself or whatever's left in the account goes automatically to Sally and she'll get the income stream. And then again, it's the same thing as what is Sally going to do with that? And we cover that through an SMSF will. He's got a commercial property that he is wholly owned with no debt on it, and it's used by Max in his spray painting business. And he doesn't charge Max any rent for that because essentially he's just living off his income stream from his super. Max is 40, and is John's favourite child. I mean, we don't necessarily like that to happen, but you'll find if you get in this business, it's just the way it is. Parents like some kids and they don't like others. So Max is 40, John's favourite child, and John wants to give him the property outright, while his two daughters, Sarah and Jodie, are to receive $100,000 each. So that's not a bad thing. It just simply, that's the way it is. Now, of course, given the Family Provisions Act, there's a chance that if Sarah, or let's say Jodie, hates Max, then if John dies, then effectively she is going to potentially take an action against the executor of the estate, if that makes sense. Now, he hasn't given anything to Sally, because Sally gets the house and she also gets the pension. So everything's looked after for Sally. Everything else is going to go to the kids. Does that make sense? So if one of the, so we've gone in and we've worked out, if one of the children dies, so that's Max, Sarah or Jody, their shares to be given to their children. And if there are no children, then to be shared to John's remaining children. At this stage, only Max has 2 children, Ben and William. So that, for example, if John dies, that $100,000 that was supposed to go to Sarah, if she's not alive or announces it, that will then go down to be split between Jody and Max equally. But if Max dies, that commercial property won't go to Sarah and Jody. It'll actually go for the benefit of his 2 children. And generally, as the advisor of the estate, you create a testamentary trust for that one, for those, because the kids are way too young to be looked after it. So what I'm going to do there is I'm going to go out. So we've got a good base and understanding now. I'm going to come out of here. I'm going to take you to the LightYear Docs site. So the first port of call for us is to actually go into our strategy center, which I'm doing at this stage. So when I go into the strategy center, you'll see here that there's a whole range of elements. This the webinar is going to be there, but you'll see here we've got how-tos. So there's lots of platform how-tos. The documentation, I've done a few videos on those, which is important. We've also got client tools. See down here. So the client tools are really your starting point and the most important starting point. So you'll see here, if you really want to learn this business and where my thoughts are and where you want to be going, because over the next, and let me just put it to you, I know COVID is a bit of an issue, but when we come out of this over the next 20 years, $3.2 trillion, 3.2 trillion is going to be passing from one generation to another. So that means there's a lot of people who need wills done. Otherwise, there's going to be a lot of intestate estates. So the public trustee will be happy. And likewise, there's going to be a plethora, a lot of challenges, obviously, against these estates. So if you want to learn how to protect estates, etc., go and have a look at this book. So it's a book I wrote, The Guide to Succession and Estate Planning book. Again, it's free. You all got access to this. You just go onto the Strategy Centre and look for the Guide to Succession, Asset Protection and Estate Planning. So that should be your first port of call for your reading. Now, we've also got here our Enduring Power of Attorney and Will letter with data capture. There's an SMSF Will Client Fact Find. So what we've got here is a letter that can go to the clients, or more importantly, you can send it out as an email to the clients. So if I was running your business, I would be sending this letter off or sending an email out to, you can see there I'm doing an annuity contract for my mother at the moment, mum and dad who are sitting in her home. If you don't know what an annuity is or how powerful they are, make sure you tune into the session on Thursday morning when we launch Australia's first annuity contract. So that's a bit of fun about our system. Obviously it creates quite we're putting on new documents every week. So this is just read what the document's about. So with your will, you've got two options, or there's actually 3 options that are available to you. If you're doing a basic will, you generally don't need to get legal sign-off because it's been signed off by Abbott-Family lawyers already, and then the process and the system has been signed off, and I'll cover that. The second one, though, is if you do have one, they've been married before, or, they've got that recalcitrant kids, that Max and Sarah don't get on, then you might want to, you go ahead and draft up the will, but then you might want to get Abbott-Family to come in and provide advice. So what we do is we sit in and you've drafted it up, you've got all the client's data, and then we come in and we have a look at what you've drafted up and we ask the client a few questions. Then we might end up making a few changes to the will. And then from there, we obviously go and have a final sign-off. And the cost for that is $495 if it's just one. But if you've got a couple, which you generally will, then $795. So that's a pretty good fee. The third option is that if you've got a really big client who's got a $5 to $10 million estate, you might just want to bring in Abbott-Family for that, and we'll come in and look after it. And then you'll obviously do a lot of administration, etc. What happens there then is we pay a 30% administration fee for it. Anyway, so what I would do is if you're doing an email, just send this out to your clients or send it out to your top 20 clients. Because the last thing you want to do is send it out and then they'll come back and say, yes, we want to get this done. So send it out. This would be it. Must do enduring powers of attorney and wills. So the coronavirus is having an impact on society. Many of our clients, so this is a letter from you, obviously, Australians and for that matter, people across the globe are concerned for their own safety and that of their family, particularly if you're in Victoria. We're asking ourselves a whole range of questions, including what happens if I or one of my family get the virus? Will it spiral out of control? What about the elderly members of the family over age 60 who seem to be more susceptible? We don't have answers to these questions, but what we do know, and that's, I've got to change that one, so do now, is that it is important, if not vital, ensure while fit, competent, and able, that you safeguard your financial affairs by giving a spouse, relative or close associate your enduring power of attorney. Now, I'll just give you a bit of a hint on that one. So, mum and dad's mum and dad's will effectively, they've currently sold the house, so they've got maybe $700,000-800,000. Now, if something happens to dad, and dad's been at home now for 3 or 4 years, he's got dementia, he's got lymphoma. Look, I'm not sure how long he'll be around, but what happens in his will, all his part of the estate, because it's sitting in a joint bank account, all passes to mum. The problem about that is that suddenly by passing it to mum, effectively it would mean that she would suddenly go from being in a position of being able to access quite a bit of the pension and also subsidised aged care, virtually go down to nothing, which would be very expensive for the family. So ideally, it'd be best to change the will such that the executors, who are myself and my brothers, can put that into a trust for the benefit of the family, but excluding mum. Now, of course, we'd still pay fees if need be for mum, but what it means is it's not part of her assets. Unfortunately, dad has lost mental capacity, so we can't change his will. So you've just got to be really careful around that one to make sure that your client has mental capacity. If you're dealing, what you need to do, if they do a will, one of the processes you need to do is, one, establish their identity, which that should be an easy process. The second one is to get a letter from their doctor that they do have mental capacity, they're able to complete their will. Otherwise, that's one of the first areas that generally gets challenged. Anyway, this enables your EPOA to act on your behalf if you become sick, quarantined for a long time, or become incapable of managing your financial or health affairs. So it's worthwhile, if you're going to go down and do a will, is to get a client's enduring power of attorney. In addition, your enduring power of attorney or your power of attorney may be given the power to take your position as trustee of a self-managed super fund if your deed allows. Each state has its own EPOA legal requirements, which we're on top of, so that you as the firm. Importantly, from that one, a power of attorney is much the same. The problem about a power of attorney is once you lose your mental capacity, your power of attorney ceases. That's why everyone does an enduring power of attorney, because it continues on past that up until the time of death. Once you die, your enduring power of attorney ceases, and then that's when the executor takes over. So that's why, if you're doing this for the client, is to best to be doing a bit of both. So apart from an EPOA, it's important to put in place a will or revisit your will if it has not been looked at in the last 2 years. And most of us got some very old wills. The coronavirus shows us that change can happen quickly, and we must prepare for change. The great safeguard of this very moment is put in place enduring power of attorney and update your will and that of your closest loved ones. So many young families have neither document, relying on the courts to solve these issues, yet the courts may be quarantined or closed, which they are at the moment. We've teamed up with the lawyers. So this is your firm. You've teamed up with lawyers and specialist estate planning advisors, Abbott-Family, to provide an EPOA and wills package in these challenging times. We've been suggesting it for clients when we do reviews, but now we see the absolute importance of implementing it for all of our clients and their families. So this is where we get into it. So the process is simple and quick if you get your EPOA and executors right. Remember, I said they're the ones who drive the bus, so to speak. So it's important to get that right and get what we call a chain of succession, a chain of executors. Who's the first if they're not alive or don't want to do it? Who's the second if they're not alive or don't want to do it? Who's the third? And you have to put that chain or that succession in, because if something goes wrong, and there's no executors, guess where it ends up? The public trustee. That's going to take years and it's going to cost a fortune, and everyone's going to get super, super frustrated. So again, we want to make sure we have that chain of succession. And the reason we do the enduring power of attorney, because generally whoever's your power of attorney is also going to be your executor. Because if they're looking after you during life, then they're obviously the ones who are going to look after you in death. If they're not alive, then the second enduring power of attorney is going to be a second executor, if that makes sense. So anyway, the person who you nominate as your enduring power of attorney can also be the executor of your will to ensure safety, certainty, security and continuity. It may be more than one, known as joint EPOAs and executors. The problem about that is, again, just going back to my family circumstances, we did have 3 EPOAs, which were all of my which were my brothers. And the problem with my brothers at that stage is that they were interstate, and with the wills and the enduring powers of attorney, they all had to be, and the contracts had to be wet signed, which means you couldn't digitally sign it yet. They are going down and reforming that, thank goodness, after COVID. But you know what the legal profession's like, it's very slow to change. So as a consequence of that, what we've got there is don't have too many. It's nice to say we're going to get all the kids as EPOAs or executors, but that then sets things up for a fight. The best thing is work out the smartest one. And if you've got everything there that is, that's structured and recorded, the executor's not going to, if they don't have much discretion, then, it's all going to end up the right way anyway. So the person you choose will look after your financial, health and super affairs in the event of an illness or anxiety, should you so choose. In addition, they will be tasked as executor with looking after your estate upon your death, managing any of your specific gifts such as property going to one or more family members, jewellery to grandchildren, well, anything you desire. They can also limit any disposition of your estate to your lineage, which is your direct descendants, or to bloodline only, which may include brothers and sisters in the event of that are main or specific beneficiaries alive. So you're going to see when we get in, and I show you very shortly the system, that effectively what we do is if the client wants it limited to bloodline, you can, and that's pretty important. Build a line, as I've said to you, of EPOs and executives. Abbott-Family lawyers advise that you should provide a successor EPOA and executor in case, when the time comes, the person or person you appointed cannot or might not want to take up the role you have endowed upon them. It also does not hurt to have a second successor EPOA and executor. Safety, certainty, security are paramount. If something happens, we want to make sure your family's looked after. As your advisor, and you can put in there as your accountant, remember you just saw me change, so you can change this, it's just a word letter, put it up on an email. We strongly recommend that together we undertake a fast and simple 3-step process to implement your EPO and will. Complete the quick data capture attached, send to us as soon as possible so we can work with Abbott-Family to draft your EPOA and will. Now, you're not doing that because you're actually using a precedent of ours to draft the will, but it just shows you've got legal credence there. We'll get together and review the EPOA and will to ensure it's tax efficient and covers all the bases. If need be, depending on the family circumstances, we may need to have a meeting or teleconference with lawyers from Abbott-Family to check the EPOA and will, plus witness the execution, which is what I said. Remember, if we're just getting a little bit, we're not really comfortable, get us involved and get through the process. We are very busy at the moment about our client's EPOA and will, the top of our list of priorities. Along with Abbott-Family, we can provide the above 3-step EPO service. Now, you can either put a costing in there, or you can just simply say we can do that, and then you can work out what it's going to be for your client when they come on board. If you would like your children and their spouses covered with EPOs and wills, we have a special family offering. Just call us. At this point, we suggest you complete the attached data capture. It won't take long. We'll get the process started and then email it or fax it to us. We'll simply post it back. There's no time to waste. The relief of getting these documents completed will take a lot of weight off your shoulders. So that's a pretty important. So from Boris, what would you recommend if one does not know who to appoint as an executor? That is, the people they trust are not financially savvy. So it's not too bad. Don't ever appoint a lawyer, please don't. It's just a complete farce. So if they're not financially savvy, the best thing to do is ensure that they have, for example, an advisor such as yourself, Boris, that sits alongside them and is the advisor to the executor. And that's what I would be pressing on the client to make sure. And you'll see in our process, in our will, that you can nominate or you can be nominated as the advisor to the executor. And look, if a lawyer, just to give you an idea, if a lawyer is appointed as advisors to the executor, the general fee is between $30,000 to $50,000 from a legal firm. That's where they get a lot of their money. So again, it's an important position there. And it's not too bad, particularly if you're accountants, because you understand the tax and other consequences around it. So let's go down to the data capture. So this is what you want back from the client. So the first thing, who's your enduring power of attorney and executor? Who is to be enduring power of executor? This may be held jointly by one or more persons. If you want different persons for the roles, write in the box the name of the person. So they might put in here, for example, we've got Max Smith, then Sarah Smith with Sally Smith. So there it's going to go to Max, then Sarah and Sally. Now, in the event that no VRE power is able to fulfill their duties because of sickness, who's going to be the next one? So it's actually there. This is your second line. Does that make sense? Oops, sorry. It's going to be Sarah with Sally Smith. So we just got Max Smith first because he's the number one son. He's smart, he's savvy. He's got his spray painting business. Now, if there's none there, then we might actually put in there Fred Jones, who's a best friend, who can sit in there as well, again. Now, enduring power of attorney, generally got the unfettered, but, is there anything that they want to put in there? So, what they can't do. So we might just say, look, ensure that any healthcare is of the highest standard or anything else. So that comes up. We won't do enduring power of attorney. Now, get down to the wills. After appointing a chain of executors, so again, we're emphasising that, to manage your estate, the next step is guide your executor with your desire to make a specific gift to a spouse, child, grandchild, or other person. Once this is done and the gifts are made, anything left over forms the remaining estate, which may be passed in its entirety to a spouse or children, individually or to be shared. Importantly, specific gifts rank higher in importance than the remaining estate. The first step is to look at specific gifts. Now, do you want to make any specific gift to any person, such as my investment property at 5 Smith Street, Collingwood, is to go equally to my eldest daughter, Jane, or my sister, Janie Smith, is to receive $100,000. Now, feel free to make as many bequests you want. The more specific gifts you complete, it makes the role of executor the much easier and faster. Now, specific bequest, this provides your executor with the authority to transfer property shares, jewellery, cash or percentage of already assets after any specific bequest to a certain group. Please be specific as possible, so on. So you can put in charities. So this is what your client's going to write in. Now, once you've done that, as I've explained, then there's the remainder of the estate. If there is any assets or monies left over after paying all expenses of the estate and also paying out all specific gifts, the remainder of the estate, called the residual estate, is passed to the main beneficiaries. So who's the main beneficiaries and what's their percentages? If they're not alive, who's the secondary? And if not, then it goes down to tertiary. So what you want to do is you just want to put that in place and then send that out to the client. That gives you good data capture. So once you've got that data capture, you'll then just jump onto our site and effectively we just click the button here and then I'm going to go, I find because we've got so many documents these days, you're best off, you can go into the estate planning section or you just go into search. So you'll see there the will, So I got, remember the SMSF will we talked about? LYD will with, so it's LightYear Docs will with Testamentary Trust? Not at all. I'm not going to do that. You've got your basic LYD will, which is okay. Or you've got an enduring power of attorney and will automation, which is generally what I would do for my client. But I'm not going to do that at the moment. I'm just going to do our basic LYD will. Now you can see up here on the right-hand side, see where my cursor is. I'm an always strategist. I can click on there and you can see I've got a dashboard. I've got my in-progress docs. I've got my vault, which is where this is going to be saved. I've got invoices, so on and so forth. So that's my guts. So because I'm on a subscription, if your business is on a subscription, then you don't need to pay for the document, just simply start the document. If you're not on a subscription, then it's simply $99. And you can have a read through here about the legal advice, general information about the will, the benefits, and also FAQ. So is this document a legal document? And you'll find if it's prepared, and there's a whole lot of cases here. So if we have a look at here, all master documents have been signed off by Abbott-Family lawyers. Tony and Willis of Abbott-Family advises that at no time due to inbuilt legal protection and security measures can a user change or amend a document on the LightYear Docs platform that has been signed off by a practicing solicitor. To do so will result in the user drafting a document of a legal nature engaging in provision of legal services. In addition, it would be a breach of copyright. In our opinion, when completing the form fields through the LightYear Docs platform, users and their employees are merely carrying out an administrative task, which is not the provision of legal services. And there's a few cases around that. So you can go and have a look at that a bit further. So what we're doing is effectively we are preparing it from that data capture. So again, it's administrative tasks. So when we go down here, we need to set up a folder for the client. So I'm going to put it into my Abbott test folder. I could always add a new folder if I wanted. So for every client that wants a will, make sure you set up a separate folder for them so it's easy to find in this server. Now, all the information is sitting on our servers in Melbourne, and effectively it's all encrypted, so we don't have anything overseas, and it's extremely private. So then I just start here, and you'll start to get to the interview process. Now, when I do this, you'll see down here there's a bottom button, support at any point in time if you need help or ideas. Just go to support, put your name, email address, and how you can help you. So because I've set it up in a folder, it's like any folder, I need to put in place what the document is. So I'm going to put in here John Smith will, because ultimately we'll be doing potentially Sally's will. And while we're there, why wouldn't we be doing Max's, Sarah, and also Jodie's? I mean, that's the whole process, do this whole family setup. Now, your firm will have its own logo and your 5-character code for the logo. But what we need to do from that perspective is, can you just simply put in your the AM001, so that's AM001, and that's the Abbott-Family logo. So now the common parties, and this is the important part as you'll see a little bit later on. So remember, I'm just going to go through and put all the details in. So I've got John Smith, and he's at 5 Smith Street, Sydney, New South Wales, 2000. And then I add, see this, I add another. So then I'm going to add his wife, Sally Smith, and then same thing, 5 Smith Street, Sydney, New South Wales, 2000. Now I've got to put the kids in. So I've got the kids, and we've got the blue-eyed boy, we've got Max Smith, we've got him at 100 Street, Fairlight, New South Wales, 2095. Add another, remember we've got Sarah Smith, she lives at 100 Brown Street, Brisbane, Queensland, 4000. And then we've got Jodie. So we've got Jodie Smith, and she lives in 100 Street, Sydney, New South Wales, who else? So she lives with Max. Now add another one, because remember I've got the old, Fred, I think, what was the friend's name? Fred Jones. He lives in 100 Street, Hanley, New South Wales 2094. Now I can keep on putting them in. I could put in, remember Max had Ben and also William. Now, if they were going to get specific gifts, I'll put them in. But I want to put in all the people who are executors and all the people who are potentially beneficiaries or going to get specific gifts. So I've got all those common parties. I'm going to save the answers there. Now, by saving the answers, what it means there is I've got all that data. So when I go into in progress docs, if I leave this document, I can go out. One of the things that's important, because this is a legal system, if you leave it for more than 2 or 3 minutes, it closes out. When you get to the end of the session, you'll find it becomes an invalid session. You can always preview the document there. And if you want answer summaries, so you want to do a full data capture and have a look at all the questions without having going back in, then essentially just go in and print that. So that's there. See that? The answer summary. Don't worry about the help. That's just for other purposes. Now, if you don't like a particular person, so I want to get rid of Fred Jones, he's not on the list anymore. See how I've just gone to that little button? I can go in and I can delete that repetition. And you can see there that the old Fred is gone. So Fred is effectively gone from that perspective. So just by deleting that repetition, he's no longer there. In fact, sometimes you need to delete it twice. So I won't put, actually I'll put Fred back in there because he's a mate. So the client, the good thing about this system is you can always change it coming back a little bit later on. So I think, forget what it was. Sorry about that. New South Wales 2894. Okay, so once I've got the common parties, say the answer, we're off and running, and then we're pretty close to where we want to go. So let's go general. So please enter the date that's going to be executed, which means it's signed. We don't know when that is going to be, so I can leave that open. Would you like to make another will for the spouse? So through using the system, we can do one for John and we can do one for Sally. I'm going to go no at this stage, but if I went yes, can you see how a whole lot of new interview questions, which are the same as John's, are important? Now, typically what a lawyer would do is a mirror will. And the problem about doing a mirror will is if it matches exactly each spouse, it doesn't make sense, because if John dies earlier, then all of the home, remember, the joint assets go to Sally, so that we need to look after that in a different way, shape or form. So it's the quick to do, but I'm just going to go no here. Now, this is important. Are you an accountant or financial preparing this document from client's data capture? Is this how documents are prepared from data capture so there's no legal advice? We go yes, and then we put in the date of the financial capture or data capture, it's 8, and then we put in our super accounting firm. And you can in fact put your own name in there if you want. So the testator is the party who is making the will. So they're making that testation. This is what I want to happen. So what I do is, this is why we have the common party. We're just going to John Smith. Now, again, the advisor, so we're going to put Boris from super duper accountants or financial planners. So that now means that you guys are now going to be part of the will. The executor, I'm going to remember it's going to be Max. See how it just all fits in there? And Max is the son. In fact, I can use just a little case there. Now, second, remember we looked at, I'm just looking at the data capture. So it was Sally, and then add another, which is now Sarah. And you can see how it comes up on the left-hand side. So now I've got Sally and Sarah as executors. Second successor, well, just in case there might be a disaster. So who are we going to choose? We're going to use, remember we've got old Fred Jones. Now, we go down further, but Losh, we've got Max, Sally, Sarah, and Fred. It's very unlikely unless we've got super pig flu or something. So I'm going to put no there. But if you wanted to go down further, absolutely. Now, binding vote, which pops up because I've got Sally and Sarah. The problem is it's nice to have them both as executors, but if one disagrees with the other about a specific gift or an action, someone's got to take full control. So we'll put Sally in there. So Sally's got the binding vote. So that's my executorship done. Does that follow? Is there any questions on that at all? So again, you've just got to get that succession. If you get that right, and this should mirror exactly what you're doing in enduring power of attorney. So now we go to the specific gifts. Is there a specific gift? Absolutely. Now, who's going to shoulder the expenses, duties, and taxes associated with the bequest? So, for example, the property is going to be transferred. Remember, the commercial property is going to be transferred to Max. So are the beneficiaries going to pay for it, or is the estate? So I would say generally it's going to be the estate. Now I just go down to next, down the bottom there. So is this specific gift to be shared equally by the executor amongst beneficiaries, or is it to be gifted directly to a beneficiary? So for example, is it to be shared equally? I can go yes, and then I'll just put, for example, my personal effects and golf clubs. There you go. And jewelry. Depends on whether you're American or whatever. So that's the first one. So you know that because I've gone yes, that's to be shared equally. Now I'm going to add another. No. So what I've got there is, remember, Max, male, and Max is going to get the commercial property for his spray painting business at 100 Smith Street. Oh, sorry, there. Smith Street, Sydney, Wales 2000. Okay, so that's covered that. This one here I've got to delete, so I just made a mistake. So I just delete that row that's not there. Now add another. So is it going to be shared equally? No, because what I'm doing now is Sarah, female, is to get, remember what she's getting? She's getting $100,000 in cash. Add another, because we know there, no, it's going to go to Jody, and then it's female, and then it goes $1,000. Now, importantly, we'll have a look a little bit later on. So I put all of those specific gifts. Now, what I've got to do is who's the principal beneficiary, and have a look through there. Beneficiary in the state of those persons take the remainder. So here I'm just going to go Sally. That's the spouse, and she's to get 100%. So remember, 1,000. Everything else is paid out. So all the specific gifts. So I just made a mistake there. So you can see on the left, personal effects. No, that's fine. So Sally Smith gets a lot. Now, in the event that she's not alive, then it's not going to go to her children on trust. It could be paid, but we will basically pay it to the secondary beneficiaries. So it can be paid to other principal beneficiaries in equal proportions, but that's not what we want. Would be paid to any bloodline beneficiary. So we're going to add another, not at all. What we're going to do now is a secondary beneficiary. And then the secondary beneficiary there, is there one? Yes. Select the party. That is going to be Max. And then the relation to the testator is the son. He's to get 33%. Now, he's got kids, so it's going to go to his kids on trust. We add another one. And then we've got Sarah. She's the daughter. And that's 33%. But she hasn't got any kids, so it's to go to the secondary beneficiary in equal proportions. Now, remember, if Sarah's not alive, her specific gift falls out anyway. It becomes part of the remainder of the estate. Now, the next one, and we've got Jodie, remember? So we've got Jodie there, and then she is the daughter, and that's 33%. So I'm short of a percent, but that can be for the executor. Now, again, it's to be paid to not the tertiary beneficiary, any surviving secondary beneficiary in equal proportions. Now, if none of those guys are alive, we've got a tertiary beneficiary. We can either put a tertiary beneficiary in, but I'm just going to go no. If it goes no, then it goes to bloodline beneficiaries. Now, it's not relevant here, but child guardianship. So if this was for Max, you'd put in there, yes, there's a child, and name the child, and who's the first, second, or third succeeding guardian. And you obviously put the name of the children. The other one is also pet guardianship. So let's put in here, name of the guardian. We'll go Max Smith. Labrador dog bouncer, and then $3,000 cash so plus pet insurance for 3 years. Okay, so you can cover that one. And then the final one is your funeral wishes. So did they have funeral wishes? Yes. So we want to be thrown off cremated and thrown off the harbour bridge. So there we go. Then once we've done that, we can then finish. And so what's happening is you can see there I've just taken the data capture, inserted the document there. In fact, with Zoom meetings these days, you could virtually talk to the client, don't share your screen, and then just do all the questions online. That's probably the easiest way of doing it. I've done that in a number of cases. So rather, you might get the data capture, but then ask them all those questions. So if there's not this first one, who's the second, so on and so forth. So then we get the document itself, which we would then send off to the client. So it's the last will and testament for John Smith. Now, this is the letter from Abbott-Family. It talks about the attached will is based on the data capture form given to you by a super duper accounting firm, uses current legal precedents provided by a legal firm, Abbott-Family, to look after how your personal effects, assets and property be legally gifted and transferred upon your death, your will. It is important that you read the following as of legal nature and extends beyond the data capture and administrative processing completed by super duper accounting, who are not solicitors and do not hold themselves out as such. So that's your way out of the advice. So what documents are attached? Your general advice letter, which we'll look at, and then there's your will as well. Now, very important. Wills can be challenged to the Supreme Court by any eligible person, including children, grandchildren, ex-spouse, and others who feel that might have been left out. So particularly where we've got Max. So if you've got any of these, then it might be worthwhile. That's when you get Abbott-Family involved, because we might need a more tailored will. So what are some of the triggers? Are you getting married in the near future? Are you separated but not yet divorced from the spouse? Do you have an ex-spouse? Ex-spouses are able to make a claim on the estate. Do you wish to exclude any close family members such as a spouse, child, or other dependent? Do any beneficiaries have special needs, big spenders, so on and so forth? Do you own a business or shares? Do any of the beneficiaries live overseas? So here, we've got it there, but you just got to be careful of Max. Now, the second one is your general advice letter, execution of the will. So how do you go about executing the last will and testament? And generally they could do it themselves, or you could simply give it to them, they do it themselves, or you could bring them into the office and you guys can do it. So print your completed will, review it carefully to make sure you fully understand it and there are no errors. Pick your preferred witnesses and inform that the document is your last will and testament. In the presence of your selected independent witnesses, not related family members, initial the bottom of each of the pages except for the final page. Sign the final page using your usual signature. Your executors for your will need to sign the documents also. In your presence, have both your witnesses initial at the bottom of each page. You need to advise your witnesses they may have to appear before a court. So then generally you would staple the document, and it needs to be a cross staple. So it's slanted at 45 degrees. stable. Make sure the document's in a safe place. If you've got us to sign off, then it comes it comes from Abbott-Family anyway, and would then go into our vault for signing. There's a whole lot of additional guidance notes there as well for the client. You've got this in here. If you've got a PDF, you can always take this out if you want, so that they don't know it's LightYear Docs. This will is made by me on Blur, so they can either insert that in, or alternatively, remember what you can do is at any point in time, I can just go into my vault. Let's say the client's coming in today. I know it's Abbott Test. I go down to my folder, and this is why it's important to name the folder. Remember, I did John Smith will. So I open that up, and then I can either download, delete, or I can relaunch. And if I relaunch, then that comes up with exactly the same fields. And that's a good thing about it, is once this system is in here, if there's changes down the track, they can always make those changes. So general, I don't know what it is, but I could put the date. If the client's coming in tomorrow, then I can put the date in at that stage. But let's go and have a look at the rest of the document. So this will is made as a correct and true record of my wishes, bequests and testaments for my legal estate upon my demise. However, it does not seek to influence or direct any trust or super fund where I was the trustee or beneficiary, because it can't at law anyway. So I hereby revoke all former wills and testamentary dispositions, which is pretty typical. Appointment of executors. I hereby appoint my son Max, subject to their consent, as executor. If Max predeceases me or is unable to willing, then it goes to Sally and Sarah, and Sally's to have the binding vote. Now, in the event that those guys aren't there, then it goes on to the next one. Now, I think I deleted that one with John. I could have made it further from there. Provision of advice. It is my strong wish that my executor obtains and considers advice from advisors Boris from Super Duper Accountants. Would sit in there. The initial administration, as I said, my executor shall call in or convert into money any part of my estate, and subject to the succeeding subclause, pay any debts, taxes, contributions, funeral and other expenses, costs or fees associated with my death, the administration of my estate, which include your fees. My executor shall then deal with the balance of my estate remaining after the payment discharge of testamentary expenses in accordance with the remainder of this will. In the event of my estate's insolvency, my executor shall not be required to use any payments that paid into my estate to pay my creditors where such payments are exempt. So you'd need to get advice on that one. So the beneficiaries are Sally, son Max, daughter Sarah, and daughter Jody. Remember the specific gifts? I hereby provide to my executor to distribute on a fair and reasonable basis all my personal effects and jewellery. If Max Smith survives me by 30 days, he's taken full and complete interest in the following: the commercial property. Sarah gets 100 and Jody gets 100. Any reasonable expenses, including duties, are to be borne by the estate. Otherwise, if I'd chosen the beneficiaries, basically the beneficiaries would basically be sitting in there. When I have a look here, the principal beneficiary, we've got Sally Smith is to get the remainder of the estate 100%, but if she's not alive, it goes to the secondary beneficiary. Now, in the event there's no beneficiaries identifiable, then it goes to the bloodline. And then we go to the secondary beneficiaries there, 33% each. Then we've got Max, it goes to his children and may be held on trust subject to the executor's discretion. If Jody's not alive, it goes back to Sarah and Max, and same with Sarah's there. And again, we just re-emphasise, in the event there was no beneficiaries immediately identifiable, the executor may distribute the remainder of the deceased estate to any person who shares the same DNA, so that's bloodline. Pet guardianship, the old bouncer goes to Max Smith for $3,000. Funeral, cremated and thrown off the harbour bridge. And then we go through the general powers of the executor, specific powers, they can create disability trusts, so on and so forth. Then we get down to the execution pages. So you can see here, testator name, it needs to be signed there, and the witness each page there, you'll see there as well. And executed by the testator, John Smith, to the witnesses who can't obviously be family members, and also signed by the executor as well, which is just simply going to be Max Smith there. So that's your really basic will. We've got a whole lot of other wills there as well. You've got, so Catherine, you've said, hi Grant, when can you run me through the moat? If I haven't got any free time today, but I can do any time tomorrow. And we've actually put the protector in the moat. So if you want to come back and I can look after that for you, I'll come back to you in an email. But essentially, that's the last will and testament. When we have a look at it, it's a very basic one. But have a read of that. You can see it's all done there for you. You've got your data capture, you've got your exclusion letter, and then you've also got as well, you've also got your execution. So Renee said, what's the moat? So I'll just show you. So essentially the way up the scale. So I would never use just a basic will. So where you've got to get to, if I go to the product categories. So the first step is, obviously we go to estate planning. So the first step is to do our LYD will. Now, if a client wants testamentary trust, for example, they've got children and they want it to be put in trust, or you've got a special child, or they've got in their rehab, then you probably go to a will with testamentary trust, which is another training I have to do. Now, if you've already got the enduring power of attorney and they've done the data capture, you might want to do the EPOA and will. So they're actually getting two there. They're getting enduring power of attorney and will. It's the same thing. You can do it for the spouse and also the main beneficiary as well. Now we then can go up to the next level, which is called the moat. And I'll just show you here. In fact, I've got one here. I'll have a look. I think it's in there, Kim. There we go. I've got a moat here. And I'll just show you, Renee, what a moat is. Don't be daunted by it. But essentially the same thing as we go through the common parties, but it's just got a lot more documents in it. So if I have a look at the documents, I can do a power of attorney. If I want, I can actually set up a self-managed super fund. If I've got an existing SMSF, I can upgrade it to, we call it our leading member, which is a bloodline style of self-managed super fund. So benefits can only go out to bloodline, even if it goes through the estate. You do an SMSF will, which I talked about earlier, and then you can do the last will and testament or last will and testamentary trust. So if you have a look at those ones, they are effectively, you can actually do all of that in one line, which is a pretty powerful tool for us to do. So, and then we've got another one up called the moat and castle. So when I do that, Renee, I always work on this one, because you can always build the whole thing and then come out, because there's too much to give to the client at once. So you still build it, but then what you might do is just give them the enduring power of attorney, or just give them the will and testamentary trust. But this is really, once you get up and running and you get, you're really confident what you're doing, you'll do the whole thing all together. It's just a much better way of doing it and allows the automation. The moat, as you can see, Bianca, you can do an enduring power of attorney here, New South Wales, Tasmania, ACT, wherever we want to go. So it includes the lot. The next one up, which is the moat and the castle. Well, the moat will also be coming online very shortly with the protector. And again, that's another explanation. But as we go through this process, you've learnt now the basics about wills. You should be really comfortable. If you're on an unlimited system, do your own will, do ones for your family, your brothers, your sisters, your parents, and get more involved in that process, because the more you get under the belt, the easier it is. And then if you do your support, you can always get the support. Okay, so do you have record for causes? Claudia, I usually have clients call in the morning. Yes, so all the Renee, all the courses, and I'm not sure about the points there, but you'll find that all our webinars that I do and trainings are basically all sitting here. So you'll see the strategy webinars, deed of gift, strategy roundtable. Here's a really good one for you, Renee. This goes into a case study. In fact, I'd recommend to all of you, if you want to see what the moat looks like in a hardcore way, up against a case study, do that moat in the deep dive, and that will get you right in that process. Law Society, I'm not sure about that one, but the Law Society. Okay, that's enough for me. But again, we'll probably, seeing there was a good number of you, I'll probably next Tuesday I'll go through and we'll do the will with testamentary trusts. So you'll get a good understanding in either that or do enduring powers of attorney. Anyway, I'll stop this recording and this I'll send this out to you later on today. It's Grant Abbott signing off.